Even if they win all their link arguments about not reenacting the law, this is irrelevant to the concept of the gains in 96 evidence. Link evidence rather than want to see this evidence indicates a political theory endorsed by the affirmative. They concede a couple of arguments. They support the notion of dualism. So the idea that there's a public-private distinction in the dominant subordination model. The arguments articulating cross-examination. The affirmative has a belief that if women can be taken from the public to the private, or from the private to the public realm, that they'll be able to also become empowered and redeem themselves. So the McKinnon 2000 evidence out of the 1AC. They also have the belief in the power constructed by males. Arcadia 96 evidence says this is a circular argument that assumes that women can only find power in fields that are dominantly controlled by men. It also assumes fundamental distinctions that are Western dualisms should not be allowed. You can see the argument this is internally to allow structural violence to determine the status quo. The alternative is much better because the mind body, and we recognize the mind and body as duly constituted. Our evidence says this is the original dualism that allowed the separation of others. At least the body was a natural construct, and the mind contains subjective interpretation to control the natural. The belief in playing the game of public versus private is the belief the subjective game of politics can change the natural order of familiar relations. Our gains evidence says this is what makes structural violence inevitable. The alternative recognizes these dichotomies mutually constitute projecting theory of the affirmative, which means if they win all their arguments about gender roles, it's irrelevant in the world of the alternative because we'll always win a solvency deficit. He says the united specifically because the bottom of this argument is to answer about these people should be able to choose between them only because they don't force them to. But the argument is not about forcing cross by the leak argument of public provided. It's about the assumptive process. The way if women can move from the private to the public, and that is the field of power relations, means that there will always be a division between those in which there will be a naturally constituted social order and a subjectively constitutional order of law. This is articulated in their Hobble evidence theory below, in which they talk about how if you hold the law accountable for that, reformulate powers relationships, means that in the world of the affirmative, women can only interpret their subjectivity in relationship to the law, i.e. the law is the only thing that can grant women power, but they ignore the fact the law is male constituted binary that is based on old Cartesian subject-object dichotomies. They say the alternative doesn't solve familiar relationships. The only impact of familiar relationships is the public-private dichotomy. I already explained the gains 97 above. This is alternative solvent. So you should read the 7th half of the round. It literally says that in a world in which you do the affirmative plan, that structural violence becomes inevitable because of the belief that women can only gain power by being transferred to the public sphere. He says we must change gender roles in order to solve relations. It's kind of funny because the last two arguments at the bottom of the criticism say that we cannot escape these kinds of gender roles, which means it's an either-or argument for the affirmative. We will still win office for arguments now. We can't transcend gender roles. They have conceded the alternative solvency evidence. He has zero argument as to why we shouldn't reconceptualize the mind and body as duly constituted. Our argument says this is good because not only does it eliminate the dividing line between public and private, but it recognizes that there's no such thing as a natural order. Our evidence says that the assumption of objectivity is what allows women to be assimilated in the status quo, which is what allows the repression of differences. This is the only impact of the affirmative case. Change word eternal link turn to your only impact scenario. He says we must win a link of difference. First, win a couple of arguments. Here is another link argument. McKinnon's legal theory used in essentialized view sets is fundamental to the same category. If you code law, these viewpoints being constructed by economy of active versus passive that does not have the exclusion of women from the political sphere. This is an internal link off with McKinnon 2000 evidence, solvency evidence, they agree on the first opinion. Gains 96. Russian to feminist theory concerning the question of essentialism. Sorry, the risk of essentialism must be taken out as adopted strategically. Most theories endorse the same doctrine of political implications of strategic diplomacy. God demonstrated the detached consequence for women adopting either the equality constructed in the essential stage according to judgment difference between fundamental statistical variations here time without discrimination, which responsibility recognizing natural difference was substituted for inequality. The McKinnon proposed a centralized conception of male and female sexualities and code law will return conservative, destructive, active notions of male and female embodiments to produce subjects who recognize themselves in regulatory discourse. The manner in which institutionally coded dismissals and AAA active part of constructing the subject McKinnon, oblivious to the effects of their own discourse and sexuality, have an ongoing construction of masculine and feminine identities, heterosexuality, sexuality, is already forbidden. There's an outline of a body distinct, separate, its integrity, and illusion achieved exception doesn't seem there's just one penalizes this pushing to it. There's never real privacy. The body can coexist with intercourse and trying to self-muscle. The muscles have to be put apart. This crossing this persistent invasion. She's open up, slow down the center. She's occupied physically, internally, her privacy. It's the same body morphologies which play the distinctive part of the construction notions of the ideal citizen, which in turn have justified exclusion of certain bodies from citizenship. Women's bodies historically been seen as unfair citizenship, often likened to territories whose borders cannot be defended. Our theory demands an ethics of difference to recognize historically conditioned nature and morality for political order and naturalize the view of the few at the expense of the experience of the many. This solves your difference, solves the deficit argument gains 96. Differences between the personal level, not only the political, also the ethical, which the third conspiracy life life can produce by encoding the preference, desires, interests, very specific body collective, such as the inactive text for addressing present contemporary issues concerning those who embark from the soul and bubble down parts of this body. This calls not only for politics of difference, also for an ethics of difference capable of the value of the different forms of body where themselves store overload and chain the gains 96 leak evidence articulated above, which means that we are winning, that only the alternative can solve the notion of structural oppression. The next argument he makes is the same prior to challenge the power relations in the state. We will a couple of arguments. First, cross by the gains evidence I just read above. We will challenge the way that the state constructs naturalized notions of citizenship, and which we believe there's objectivity of law that control the subjectivity of the social body. This is the link argument I said at the top of the debate. They've also said the state and law as well as they both exist, both the alternative, but our theory does not focus on the individual, but the interaction between bodies and form of community. This places responsibility on our scores, the overall historically specific values forces to examine and change structural policies lead to oppression. We refuse universality, we should always strive for something better. This will reformulate the law in a way that is more beneficial to all identity formations. Gains in 96. An analysis limits itself to individuals their effects not being more coherent, but doesn't the notion of justice or morality to be historically culturally variable. This creates agent difficulty for those who responsibility value lies in the claim that a community of rational beings which assumes some responsibility, particular constitution, such as something directed away from punishment of individuals and towards social and structural causes of such behavior. Also, our political theory reorients the purpose of the state rather than having laws commanding forces institutions are coextensive with social bodies. They control the state becomes a reflection of the people. Each is responsible for the law. The other state policy and method for controlling the vote of the people, allowing the individual and political body to become reflective on values so they may expand and change, i.e. we make good state judge, Gatins 96. Those who claim to know necessarily promote a liberal political policy, turn a blind to the difference between him and liberals, most not dissolve the existence of special rights, property, persons, private, civil rights, postal sovereign, has a much greater responsibility to enforce citizens, some liberty, social protection, citizens, prayer, private rights, justice, responsibility in the civil body, go much further than tax protection, sustainable fair, private protection, citizens, interpretation, values, are rarest responsibility in the civil body, practice, situation, also in the actual behavior of the values, citizens, which the sovereign first come from the body population, protected by the social institutions, social understanding, laws, command, and promulgated way will have an inhibiting effect on the development of capacity, citizens, since obedience is not knowledge, and best only imitate knowledge, distinguishing grasping laws, arbitrary command laws, knowledge that marks the difference between human freedom and human bondage, state that encourages obedience without understanding we want citizens are incapable of either acting or expanding their powers of acting. This would be a bad government with bad laws. Those who act directly constitute a community of rational being. Those who react in the second manner that is indirectly can easily become a society of slaves. This view of the law in civil society obviously begs the question in relation to those who are disadvantaged by civil arrangements. For example, indigenous people, women, and others. This evidence is damning in saying that it's not allowing the law to say that it's some fundamentally ahistorical objective interpretation that controls the social body. It's what makes us all slaves to the mastery of essentialism in the first place, which is another internally turned to the affirmative case. They say that Morrison on the books means solves the being the law. This argument is answered above and saying that we've shaped the law. We don't have to win. We overturn the same notion of Morrison. You can see the alternative evidence that says that if you were to adopt this interpretation of legal theory, then in the future better laws will be created. They do not reenact the law, which means they have no solvency in the world of the affirmative plan, because all of the affirmative advantages not just stem off the notion of the Morrison decision. They assume a world in which women can come to the court. They have conceded that post the plan you don't even reenact a civil remedy, which means post the plan Morrison's not on the books anymore, but women can't go to the court if they're sexually assaulted. This means there's no risk of an affirmative advantage, and only a risk the alternative will be able to solve better in the affirmative case, especially since our facts outweigh. He says you must engage in a legal system buried in 2002-2003 evidence. This evidence literally just says that women get to view their own subjectivity whenever they confront the law, but they concede a couple of internal link arguments. The Gatins and 96 link argument next to the top debate, as well as the McKinnon link evidence, both articulate that the way that they confront the law is a bad way because it assumes that the notion that the law is where all public displays of power are confronted, which means they obfuscate the way the power places itself out in the private dichotomy. They believe that there's a liberating force in going to the public, but that liberating force is always a body presupposed by men. This is the Gatins 96 evidence, where the one to see its permutations. All the permutations will be in the 1 and R. I'm going to drop down to the Epstein evidence. They say that perfect categories are impossible. This is exactly the theory of our alternative. This is more often for the negative than the affirmative. The affirmative assumes that there can be perfect categories because of the notion of the Western dualisms. The argument explained above ours are the alternative evidence from the 1 and C talks about Spinoza's evidence agreeing that perfect categories are impossible, which is why we should not feel that there are objective interpretations of the body that are played out and controlled by subjective interpretations of the mind. This is the slave mastery argument I said above. They read this word evidence says you cannot transcend gender dualism. This is precisely the point of our argument. You cannot transcend gender dualism, nor can you transcend, or you can excuse me, our alternative is antithetical to this. You can transcend gender dualism. They concede the argument that they believe that gender is some sort of a priori or only socially constructed argument, whereas sex is some sort of naturalized constructed argument. The two play out against one another, but our argument is that those two mutually constitute one another. They concede the original link evidence that says the idea of the subordinate active-passive model that their legal theorists implement is a wrong idea because it ignores the way that femininity is experienced different from a male body and a female body. The affirmative assumes that everything comes down to the notion of gender, that it is the masculine versus the feminine, but they fail to realize that femininity is experienced very different for someone who's sexually a male versus a female. Our evidence says this is a bad way to look at things because it forces people to conflate to generalized notions of gender that allow the state to subordinate them in a way that is more violent than what the act is trying to solve. They read this McKinnon evidence that says that we do not allow the escape of victimization because we don't confront the law. I've already answered the law of good argument as well as we internally turn to the McKinnon's legal theory in general that I extend above, but incorporating women into conflict order is not enough. Only a theory that examines historical cultural situation of law can mitigate oppression. Gatins 96. Ethical problem concerning legal treatment made out of a woman or a way of being not represented decisions, institutional influence highlights historical body nature, ethical relations, outlandish women, franchise, custom laws, continue to benefit scars, institution, root, formal affairs, women's socio-political war, institution, not full participate in legal institutions, function, ways people complete women powers of action, there's some the diverse fresh ways, sexual natural women by the paradox being considered both free rational members, democratic, political body beings under the natural authority of men.
Can you explain to me the alternative somehow to reshape the law?
The alt evidence is all about the way that we linguistically articulate legal theory. The way that we linguistically believe that power relations work out in the law. It's where alternative evidence.
Or we being
Everyone in the, I don't know, the people debating, they're obviously just observers. I don't know.
So,
I don't know.
in a way where we vote for the negative, when does the reform actually occur?
Our evidence says that if you take intellectual stances and you advocate the reformation of theory, that it doesn't give it an answer.
Okay, so
go
in this
with
reform,
ways.
does it reform the entire system, or does it reform within the legal system how we have legal systems?
I'm sorry, I didn't hear.
Does it reform the entire system in general, or does it reform the way we believe of dualism?
Well, it's the legal system. It's all about the way that we should view legal theory. I mean, this is the framework we posit. That's
So, post the alternative, what does legal theory look like?
Post the alternative, what does legal theory look like? Well, I thought I explained this relatively well. But right now, there's the theory of the notion that there's this objective, ahistorical law that can make determinations about the subjectiveness of the historical body. In context of the affirmative plan, you believe that familial relationships are socially constructed, while at the same time you believe that if you go to the law, it can objectively remedy the problems. Our evidence says that's a bad way to look at things because they're both subjective.
Could an individual not choose to go to the law?
Constitute one another. Could the individual choose to not go to one
Could
another?
the individual choose to go to the law?
Yeah, the individual could choose
So
to
how does
not
the
go
act
to the law
force
or
them
to
to
go
go
to
to
the
the law?
law. It's not about forcing. This is what I've been trying to explain, is that it's not about forcing people to go to the law. It's about the assumption of the 1AC that if women are empowered to go to the law, that is the remedy of liberalism that allows them to become equal to men.
So I
While
say
failing
you
to
can't-
recognize
when's the
that
views
they
of where
never
they get
do
the
so.
empowerment from?
Huh?
Where do they get the empowerment from? Like, what do we do the 1AC that empowers them to go to the law?
The entire thesis of your 1AC is Morrison decision bad because it kept domestic violence as a private
Is the
matter.
thesis of the 1AC
We
that
should
they
make it a
just
public matter and put it in the
Hold on,
political
please.
realm.
Hold on. Is the thesis of the 1AC not that the judges who made the decision confront their idea of it?
That is,
it
you
empowers
do
them
read
for women?
a card about that.
A few
And
cards
even
about
if that is the entire thesis of your ask, then let's take away the women part. Your assumption is that if judges realize that public is where power is played out, and you shouldn't you shouldn't subordinate the private, then they will be remedied. I mean, it's the same thing. You're just changing who you think you deal with, women or judges.
How is McKinnon essentializing?
Huh?
How is McKinnon essentializing?
That is off of the McKinnon 2000 evidence. That evidence just says that it talks about what I just said. McKinnon's view of sex as being empowering once you take it into the traditionally dominant sphere of private is bad because it reinforces subordination of women. It uses the passive action, which is destructive.
It's going to be framework, and then